Hello, fellow law nerds. Welcome to another episode of Boom Lawyered, a Rewire News Group podcast hosted by the legal journalism team that isn't loving this authoritarian regime. Just not really a big fan of it. I'm Rewire News Group's co-chief content officer, Imani Gandhi.
And I'm Jess Pieklo, Rewire News Group's other co-chief content officer. Rewire News Group is the one and only home for expert repro journalism that inspires you to go outside, take a breath, and take a beat because things are about to get real wild around here. And the Boom Lawyered podcast is part of that mission. So a big thanks to our subscribers and welcome to our new listeners and viewers. Oh, hey, did you notice something new in your feed, Boom Lawyered fam? It was the first episode of Bitch Listen, and oh my God, it was glorious. It was everything, Imani. I was hoping it would be. Francesca's gorgeous. I know that's not the point of any of this, but my God.
She's so gorgeous, it's almost annoying. Like, she showed up like no makeup, just flawless skin. I loved everything about that interview. I particularly loved the bit where she was talking about how she learned how to hit on women in gay bars. And then she did this thing where she was like, you got to look in the person's eyes and say they're really striking. And I was kind of like, okay, Francesca, stop hitting on me. Like, I really felt like a jolt. So my goodness. Yeah, she's freaking fantastic. So excited. My upcoming guests are as fantastic. If you haven't heard it yet, go listen, go watch, and then stay tuned for the next episode.
Really, there is something for everyone in this episode, and I have no doubt that future guests like Ellie Mistal will deliver as well. So hearty congratulations and kudos. I am so proud of you as your friend and coworker to see this out in the world, and I'm loving all of it. So yay.
Thank you. Yay.
All right. Can we be done? We don't need to talk about the court. That was fun.
All right. Podcast over. See you on the tubes, folks. But no, we got to talk about what the fuck is going on in the world in our new segment entitled, What the Fuck is Going On?
That's really what it's called.
That's what it's called. Just WTF. Last episode, we introduced a new show segment that is basically what the fuck is going on, where Jess and I each bring a news story that we want to talk about for reasons. So Jess, what do you have for me this week?
Okay, I know this isn't like hot burning right off the presses, but I have to talk about RFK Jr. announcing that HHS, Health and Human Services, will review the quote unquote safety of mifepristone. Then that's one of two medications used in medication abortion in this country.
Yikes. Just yikes. And the thing is, you and I have been talking about mifepristone for years now. And we talked about the fact that even though during the first round of litigation, they weren't going at, or they were not allowed to go after the initial authorization in 2000, but that's what they're going after now. We said that they would, right? Yeah. But now they have this jamoke at HHS who doesn't believe in science, who doesn't believe in vaccines, who's absolutely a eugenicist. And so, yeah, they're just going to go ahead and find a bunch of junk scientists to say that mifepristone is so dangerous. It's going to kill your family. It's knocking over telephone poles like some kind of out of control villager. And it just sucks.
It does. And especially because what this is an AstroTurf campaign for a national abortion ban. And that's really what I need listeners and viewers to understand, right? As you said, since Dobbs, the antis have been coming for abortion pills. And with RFK Jr., they think they have an opening now. So here's some of the background. Back in July, a group of Republican attorney generals wrote HHS complaining about the purported dangers of mifepristone and urging the agency to undertake review of do something, Kennedy, please, anything, okay? This is either pretext for rolling back approval or revoking it entirely. Now, I just got to note something here. We have over 100 studies on the safety of mifepristone, and its approval has been on the market for 25 years. We just last week celebrated 25 years of mifepristone. But the Republican attorneys generals did this because of their attempts to get some kind of national ruling from the courts to block mifepristone. Access so far has failed. Imani, you alluded to it earlier, right? We all remember the Alliance for Hippocratic Medicine case from last term, the one with the cooked up advocacy group and, filed in Texas. Well, that legal challenge is still bouncing around the federal courts. And guess who has taken the helm of it? the Republican attorneys general. So,
Ay, ay,
anyway,
ay.
this is just a big ruse. The antis are very mad about the use of telehealth and pills by mail, and they've targeted those 2 points of access specifically. Though we all know that if you give the antis an inch, they'll take the whole damn field.
Mhm.
And I gotta say it, not to like be completely like tinfoil hattish here, but I don't think it's fully a coincidence that Kennedy makes this move in the same news cycle as the administration declares war on Tylenol, right? It is the same playbook going after vaccines and medical safety as, they have with abortion. And now they've created a rebuttal to the it's safer than Tylenol talking point that we've used around mifepristone for decades. So, big thumbs down from this girl here on Kennedy and mifepristone review.
That's actually really smart. I hadn't considered it. The idea that they're going after Tylenol partly because we've been screaming about how mifepristone is safer than Tylenol. You're very clever, Jess. Very smart.
I don't know if it's specific. Maybe they are that devious, or maybe they just got really lucky. But either way, we need to now think of a new rebuttal because they're going to be like, bitch, whatever. Tylenol's not safe when Tylenol's very safe. Don't listen to them.
Also, I just think it's really just another plank in the war on women, right? The war on parents, birthing people. If you can't take Tylenol, then you just want people who are pregnant to suffer because it's the only painkiller they can take. And also, Donald Trump got on Truth Social and was like, and also don't give your children Tylenol. Like, why are we taking medical advice from these fucking jackasses? It's really frustrating to me.
Don't take their advice.
Do not. Do not.
So what do you got? What do you got
what
for
else
us?
is frustrating to me? Just the existence of Clarence Thomas.
Oh, dear God.
Just his existence is very frustrating to me. So Supreme Court Justice Clarence Thomas gave one of his little speeches at Catholic University I love saying little speeches. That's such a black thing to say. What, you think you and your little friends are going to come over here? Oh, you gave one of your little speeches? That's nice. But he did. He gave a speech at Catholic University of America's Columbus School of Law in Washington, D.C., and what he said is no surprise to those of us who've been paying attention to Uncle Clarence for years. But for those who haven't, strap in. Here's what he said about precedent. I don't think that any of these cases that have been decided are the gospel. And I do give perspective to the precedent, but the precedent should be respectful of our legal tradition and our country and our laws and be based on something, not just something somebody dreamt up and others went along with. What is he talking about? I'll tell you what he's talking about. He's talking about substantive due process rights. Substantive due process, for those of you who don't know, are the sort of privacy rights that relate to the intimate part of your life, right?
Yep.
Who you marry, whether you give birth and how you can stop yourself from giving birth, whether it's through abortion or contraception, who you can shag, where you can shag them, that sort of thing.
Did
right?
you really just say shag?
I did. I watch a lot of BBC. You know this.
You watch
about
so
me.
much. It's great though, but really shag.
Who you shag and who you snog.
Oh my God, I love you.
But, the brass ring right now is marriage equality. And I really have a little bug up my ass about the discussion about marriage equality when it comes to the court, because you see reporting from people and it's always like, legal experts agree that same-sex marriage is not on the table. And I'm like, I'm a legal expert and I don't agree. I don't agree at all. Jess is a legal expert. I know she doesn't agree.
Right.
And I wrote all about how the court is going to eliminate marriage equality, if not with the Kim Davis case that is currently on tap, then some other clean case that doesn't involve the most annoying woman in the world, who, by the way, also needs a goddamn haircut, right? And here's a spoiler alert. They're going to use the same history and tradition test that has become the sort of bellwether for the Supreme Court when it comes to substantive due process cases, like the 1997 case Washington v. Glucksberg, where the Supreme Court said that there was no history and tradition of euthanasia, and therefore you don't have a right to physician-assisted suicide. The court used that 1997 Glucksberg test in the Dobbs case, right, to eliminate the constitutional right to abortion. So if you want to listen to people who are poo-pooing the idea that marriage equality is on the table, well, good luck with that, right? And just for the record, Kim Davis is that clerk who
Oh, yeah.
refused to provide marriage licenses immediately after SCOTUS dropped the Obergefell v. Hodges decision, the case that legalized same-sex marriage. And she's been complaining about it ever since. Literally the day it dropped, she decided she wasn't going to issue marriage licenses, and she's been fighting it for a fucking decade. If you want to hear the real news about the marriage equality, just read my piece about it. We'll link
Yeah.
it in the show notes. It's a good piece if I do say so myself.
The justices just do not care anymore. And it used to be that they would signal that kind of, retreat from norms and the rule of law in their opinions or in a concurrence or, whatever. But now they're just saying it out loud and in public. And that's a little terrifying, but I think at the same time, actually an excellent segue to the preview of this court's term, unfortunately.
Despite the fact that we are in the middle of a hostile government takeover, the Supreme Court justices are just insisting on carrying on like it's business as usual, right? Like we're not being led down the primrose path to hell by an orange menace who can't remember where he is at any given time, right? And that means we have another term to preview for you.
It does. Like they could all just take a sabbatical. We'd be
a
fine with
nap.
it. Guys, you need a break.
Yeah.
It's
we need a break
work.
from you.
Imani's right, and I love that we're like kicking off the start of John Roberts' 20th helm as Chief Justice. Democracy is crumbling and the justices are like the Spider-Man meme, right? Like all pointing at each other like, I don't know, we're all trying to find the guys here, right? Like it's bad. And I just think that, we've got new folks to the show, so they may not even realize that the start of the Supreme Court term is this red mass that they have the Sunday before, right? This like Catholic mass where the Catholic justices, including Sotomayor, but the vast majority of the justices now, since it is a Catholic court, go and pray for, the country and the upcoming term. And I just think red mass, it hits a little different this time around.
More like red wedding, if you ask me.
I know, right? Right? Like it's just the vibes are in shambles. Is where they're at. So I guess we're going to do it.
So Jess, as our resident Cassandra of the court, what cases does the court have on its docket that our audience should know about and probably fear?
Fresh off that Catholic Mass to kick off the term, the justices will hear arguments on October 7th in Childs v. Salazar, a case challenging Colorado's ban on conversion therapy. Now, Colorado is one of 23 states plus Washington, D.C. that bans the practice of quote-unquote conversion therapy.
Colorado, throw them up. What? I don't think anyone's ever said Colorado, throw them up before.
But I managed to whoop.
So conversion therapy is kind of an umbrella term that encompasses a bunch of programs and practices to try and change someone's sexual orientation or gender identity, right?
Yeah.
Sometimes it's been called reparative therapy or ex-gay therapy or sexual orientation change efforts or SOCE. You're going to see that acronym a lot, SOCE. But here's what you need to know about it. No matter its name, the widespread medical consensus is that these efforts are harmful at best and abusive at worst. They do documented harm. According to an amicus brief filed by former conversion therapy practitioners, 99.9% of participants don't change their sexual orientation. The brief also lays out how these practices cause documented psychological harm, including increased suicide risk, particularly among LGBTQ youth, right? The brief also lays out how conversion therapy undermines rather than strengthens families by creating conflict and damaging parent-child relationships, and also lays out how regulations protecting minors from these practices align with established professional, medical, and mental health standards while preserving legitimate therapeutic relationships.
And just to reiterate, the practices are so bad and so abusive that, like I said, 23 states in DC have banned the practice outright. Well, Aaron Hawley and the Alliance Defending Freedom have now entered the chat. That's the only appropriate reaction to Aaron Hawley entering the chat. They represent a Christian therapist by the name of Kaylee Childs, who argues that Colorado's ban, and by extension, any similar ban, violates the First Amendment because it is a viewpoint-based restriction on speech. So, she, the Alliance Defending Freedom, challenged the Colorado ban, and they lost. They lost. The 10th Circuit Court of Appeals, which hears appeals from Colorado, Wyoming, Kansas, Oklahoma, New Mexico, and Utah, disagreed and said, no, 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 no. Colorado's ban regulates conduct, a particular practice, the being a conversion therapy practitioner, not speech, not what you're telling people, right? It's different. So the question of whether or not bans on conversion therapy regulate speech or conduct has created, Imani, you're actually maybe going to like this, an old-fashioned circuit split.
Ooh,
Remember
I love
those?
me a circuit split.
We have a circuit split in the federal courts with the 9th and 10th Circuit Courts of Appeals saying that these types of bans regulate conduct, and the 11th and 3rd Circuit Courts of Appeals saying it's speech. So it looks like Clarence Thomas and Sam Alito get to settle the split.
And for new listeners, a circuit split is just basically when different courts of appeal come out differently on the same issue. And generally, the Supreme Court likes to resolve circuit splits because you want law to be applied nationally across the board, not like abortion law, which is just like a patchwork of laws in different states anymore. Normally, we want just uniform law, right? But we know exactly how the Supreme Court is going to rule in this case.
Yeah.
Alito and Thomas basically told us already. Back in 2023, the Supreme Court passed on a case out of Washington called Tingley v. Ferguson.
Mhm.
But Clarence Thomas, never one to keep his bad takes to himself, wrote a dissent whining that the law forces counselors to stick to, quote, state-approved opinions. State-approved opinions like, I don't know, don't abuse your children and try and change their sexual orientation or gender identity, but I digress. This was after he proclaimed that there is a fierce public debate over how best to help minors with gender dysphoria. Now, incidentally, there seems to be a wide consensus, as we've talked about, that conversion therapy doesn't work for sexual orientation.
Mhm.
But now we are in the throes of a trans panic, a ginned up trans panic by conservatives, right? So Thomas's statement about gender dysphoria, I think, portends the resurgence of conversion therapy to reduce the number of trans kids, right? Which will, of course, then will be used to reduce the number of queer kids. So it's like, we've agreed that sexual orientation can't be changed and conversion therapy is bad, right? Like we've all seen But I'm a Cheerleader, that awesome movie from the late 90s starring Natasha Lyonne, where she goes to like a camp to try to get the gay, prayed away from her. It's amazing, amazing film. But we kind of all agree on that. But now that we have this trans panic, I think that is going to be used to re-up the lavender scare, to re-up the idea that sexual orientation is something that should be changed and something that is deviant. And this is happening all over the country, right? The bullshit panic about trans people being used to relitigate debunked bullshit about sexual orientation.
Completely. And I just got to say this real quick, that I love how Thomas is concerned about a state-sponsored script in this instance, but has absolutely no problem with states mandating what abortion providers can and cannot tell their patients in the process of delivering care to them. I mean, Jesus Christ. Okay, sorry. Thank you for that moment.
The hypocrisy is just really stunning.
It is.
And it's not just Justice Thomas. Sam Alito also had things to say when the Supreme Court declined to hear the appeal in the Washington conversion therapy case, right?
Mhm.
Alito jumped in to say that this is a matter of, quote, national importance, and that it is, quote, beyond dispute that these laws restrict speech, and all restrictions on speech merit careful scrutiny. And then we've got Justice Kegstan, our favorite guy, Brad Kavanaugh, who was basically like, yeah, me too, right? He wanted to grant the petition. Was that a Me Too joke? It wasn't not a Me Too joke. I'm just saying. Right? The court didn't take the Washington case, But with Thomas Alito and Kavanaugh already waving their pitchforks around, it's obvious where this is headed when it comes to the Colorado case.
Already on social media, I am seeing, conservative Christian influencers rallying around this therapist saying all she wants to do is try and help kids become comfortable in their bodies. So there's going to be a lot of, artificial care around expressed for queer kids that this community would otherwise cast aside. So that's October 7th. Imani and I'll have a deep dive on the case, but they're coming in hot this term.
Super hot.
Oh, okay. So I got another one that we got to talk about. Imani, do you remember Becky Pepper Johnson?
Becky Pepper Johnson. First of all, I love Becky Pepper Johnson, and I do remember Becky Pepper Johnson because we did an entire episode where we called her Becky Pepper Johnson, but then it turned out her name is actually Becky Pepper Jackson.
We're so sorry.
The whole episode, we called her Becky Pepper Johnson. So we had to provide an editorial correction to the podcast that was like, we're sorry, Miss Jackson. Woo, we are for real. Honestly, these Gen X references just never get old. They never get old for me.
They don't. That was such a great episode too. We had so much fun. It was one of our most sort of roaring and enthusiastic, sort of rebuttals against all of the anti-trans athlete stuff. And man, we did. Fun. We face planted on the name.
Really
so
face planted.
hard.
But we hope that Miss Pepper Jackson accepts our apologies.
Well, we have an opportunity to redeem ourselves because their case has landed before the Supreme Court. So
what a mess. So
take it away.
West Virginia has a law that bans trans girls from participating in all girls sports teams from middle school through college.
Yep.
The ACLU has argued that the ban violates Title IX of the Civil Rights Act. Title IX is the federal civil rights law that bans sex-based discrimination in any education program that receives federal funding. The Fourth Circuit Court of Appeals agreed with the ACLU and blocked West Virginia's law. The Fourth Circuit is the court that hears cases from West Virginia, Maryland, and the Carolinas, both North and South. So, West Virginia filed a cert petition with the Supreme Court, and here we are. SCOTUS will decide if West Virginia's law violates Title IX and the Equal Protection Clause.
It's really hard to overstate the impact that this case could have on trans athletes and access to sports for them in general. And it stinks because it's the second trans case in as many years, and where for the first time we saw a glimmer of the court actually acknowledging that trans folks should be treated equally under the law. It sucks. I wish that this was not a case that we had to talk about this term, unfortunately.
It does suck. And what I think sucks even more is that there are so many people who are falling for this shit. This ginned up trans girls in sports controversy that affects about 100 people in the entire country. I think Becky Pepper Jackson is the only trans girl in West Virginia who's playing sports. I think that's correct. But in any event, when you combine K through 12 and college, it's less than 100 people. So it's obvious that conservatives have, over the last decade, ginned up this trans panic, and they're using trans girls in sports in order to further their anti-trans goals. And Democrats are falling for it, left, right, and center, right? You got Pete Buttigieg talking about, oh, well, parents have actual concerns. No, the fuck they don't. They actually don't. And you don't need to pretend they do in an effort to both sides an issue of human rights. It's really irritating.
And like we've talked about, it becomes a question and an issue then of whose parents have rights in this conversation, right? Because they're certainly not talking about the parental rights of trans kids in that case. And we saw that last term with Mahmoud. The cherry picking of, who gets rights and who doesn't is becoming kind of at a fever pitch here.
Right. And Scrimeti, parents don't have the right to get their kids gender affirming care.
Right.
And now, apparently, if they do, it's child abuse.
Right.
I mean, what are we doing? Whose rights matter? Whose parental rights matter? It's not the parents, as you said, of trans kids.
Okay, well, my apologies, but we have yet another Alliance Defending Freedom case that we have to talk about.
I don't want to.
I know. I really don't want to either. This one is First Choice Women's Resource Center versus Platkin. And I'm just going to say it, folks. I hate this case. This case is terrible. I hate it. I want it to go away. I don't know why it's here. It's here because the Alliance Defending Freedom has like a, one-way ticket to the conservative justice's heart, and they are just going for it apparently this term. Okay. So we're going to talk about it, but briefly, because like I said, I hate this case. And it really, it's terrible. It sums up the so-called crisis pregnancy center grift so perfectly. All right. So Imani, here's the question presented, the question that the Supreme Court is asked to answer in the case at hand. I'm going to read it to you and you can decipher what it means. Okay. Ready?
Yeah.
All right. Where the subject of a state investigatory demand has established a reasonably objective chill of its First Amendment rights, is a federal court of first filed action deprived of jurisdiction because those rights must be adjudicated in state court?
Literally what? Like,
I copied and pasted that for the record. There is nary a typo to be found.
Like, what is this supposed to mean? I don't get it. I've read it multiple times and I just keep coming back to, I'm sorry, what now?
Right. Would you have any idea that this case is about a crisis pregnancy center trying to avoid a subpoena from the state of New Jersey to disclose business related to information like donors as part of an ongoing investigation as to whether or not those CPCs violated New Jersey's Consumer Fraud Act? Because that's what this case is about. CPCs run into the federal courts to try to protect their grift. But you'd never know that if you read the damn cert petition.
I mean, where the subject of a state investigatory demand has established a reasonably objective chill of its First Amendment rights, is a federal court in a first filed action deprived of jurisdiction because those rights must be adjudicated in state court.
Everything just immediately went to the teacher in Charlie Brown's voice.
Absolutely. And like, look, these CPCs, they stay running to the federal courts complaining about shit. It is reminiscent to me of the NIFLA v. Becerra case, right?
Definitely.
That California case where California was like, hey, man, if you're a CPC, maybe stop lying to your patients. Maybe tell your patients that that you don't provide abortion services, and maybe let them know where they can go find them. And the CPCs were like, wah, it's no fair, right? They convinced the Supreme Court that forcing them to tell the truth about what services they actually provide somehow violated their First Amendment rights, right? So in other words, in NIFLA v. Becerra, they secured the right to keep misleading patients. And patients is even doing a lot of work because these motherfuckers aren't doctors. They're just consumers, really. They got the right to continue to mislead their consumers. Mm-hmm. So of course now, when New Jersey wants to know whether these CPCs are defrauding people, and they are, they're back in federal court clutching their pearls about subpoenas.
That's exactly what they're doing. Alliance Defending Freedom is like, yes, that sounds great. Let's help.
They're just the fucking worst. You know what else is the fucking worst?
Huh?
Louisiana.
Oh.
I mean, not people in Louisiana.
We love you, Louisianans.
We love you, Louisiana. The Louisiana legislature, particularly Republican. So we got to talk about this case, right?
Yes.
The Louisiana redistricting case and what it bodes for the future of the Voting Rights Act and minority representation.
Yeah.
So Louisiana v. Calais is just a whole ass mess, right? Just
definitely is.
Just mess from top to bottom. So the question the court will answer is whether Louisiana violated the United States Constitution when it intentionally created a second majority Black congressional district to comply with the Voting Rights Act. And if you're wondering why I called Louisiana a whole ass mess, it's because they decided to create this majority Black congressional district, but are no longer defending that map.
I couldn't possibly have heard this correct. SCOTUS is going to decide if complying with the Voting Rights Act is racist?
Yeah.
Did I get that right?
Yeah. Yeah.
What?
Yeah, you did.
What?
Yeah. I know. It's ridiculous. That's why you're flummoxed right now.
What is happening?
Right? So Louisiana has a population that is approximately 30% Black.
Yes.
But the original map included just one majority Black district out of 6.
Okay.
So it's almost the same damn case as, do you remember Allen versus Milligan? Which the court decided in 2023. So for those who don't remember, and you might not remember because shit is a shit show and you're probably just trying to stay alive right now. But in Allen versus Milligan, the Supreme Court affirmed that Alabama's congressional map illegally diluted Black votes, and they required the creation of a second majority Black district under Section 2 of the Voting Rights Act.
Mm-hmm.
I don't see a difference between these two cases. Like, what's the difference between Louisiana v. Calais and Allen versus Milligan? They're both about whether or not Section 2 will be struck down.
Mm-hmm.
2 years ago, even Roberts was like, y'all, this Alabama map is hella racist. And John Roberts has literally spent his entire fucking career trying to undermine the Voting Rights Act. So if it's too racist for him, it's really goddamn racist, right?
Yeah.
So what's the difference besides new president, new rules? Are they going to go? And I remember you and I talking about this because we did a whole podcast episode about Allen versus Milligan.
We did.
And about Sam Alito, whose argument essentially in the Alabama case.
And I forgot about
that,
this.
And get this. In order to draw a second majority Black district in Alabama, you have to account for race, right? Like, you got to figure out where the Black people are and where the white people are so you can draw the goddamn district. But Sam Alito said that accounting for race to make maps less racist is in and of itself racist.
Yes.
I can't. I won't. I refuse. Like, are you fucking serious right now? What is happening?
Here we are. Like, you know.
And why are we here? Right? Because it's not like, oh, it was a hugely liberal court in 2023 and they agreed that no, we shouldn't gut Section 2, basically the only remaining section of the Voting Rights Act that has any teeth when it comes to Black people being able to sue for violations, right? Why are we here 2 years later with basically the same exact fact pattern? It's weird. We are like
shades away from Sam Alito just declaring the 14th Amendment racist.
Oh God, we are.
Like,
we actually are.
I'm making jokes, but they're not that funny. Like, in terms of, gallows humor, like, it's the idea that Louisiana was like, all right, this isn't going to work. Like, we need a second district. And the court is like, that's racist.
It's racist to let Black people vote.
It's racist for Black people to have proportional representation.
Like, how do you have a 30% Black state and one majority Black district?
You have 3/5 of representation. Like, that's
go.
what they're talking about.
Yeah.
I mean, what the fuck, Imani?
We said in our opening episode that we are in the deconstruction era. This is quintessential deconstruction, right? Actually arguing that trying to account for racism by looking at racial makeup of different areas and saying, no, we need more Black majority districts. That in and of itself is racist. How are you supposed to tell whether something is racist without taking race into account?
And I made a joke about it during the upfront, but really, I think, we're all watching to see how democracy in general is going to fare this term. And so far, survey says not well, right?
Not great.
So get this. CNN journalist and John Roberts biographer, Joan Biskupic, published a piece recently on how it's no longer the Roberts court and it's fully the Trump court. And I just got to say, at 20 years of John Roberts at the helm, that one's got to sting.
Yeah.
And kind of like the last episode and the federal judges going on record that they think SCOTUS has jumped the shark, I know that kind of statement from Biskupic doesn't sound like some kind of radical proclamation on the status of the Roberts court, but that's actually kind of a pretty big call out in, after all, we are in the world of access journalism and nobody has had access to the chief quite the same way that she has. So, to just flat out on CNN call it the Trump court is, wow. Good job,
but
Joan.
That's what it is.
It's what it is.
That's absolutely what it is. And John Roberts, I think, has been at the helm of the most regressive Supreme Court in modern history. He's like, and as far as I'm concerned, he's right up there with Taney.
I was just going to say, he looked over at Taney and said, hold my beer.
Exactly. And for those who don't know, Taney is
That's the nerdiest joke.
It's such a nerdy joke.
But it's a good one.
Good old Roger B. Taney, who just loves separate but equal. Oh, for Christ's sake. What's on deck? That's what we need to talk about next.
Yeah.
Because once again, we're living through another huge Supreme Court term, right? Huge. So Here's a quick little look about what's next for Boom
Oh,
Lawyered.
yeah.
We're going to do a deep dive on the Colorado conversion therapy case next, right? Next week, oral arguments in that case, October 7th. We are going to be on it for you.
So oral arguments are when Imani and I are recording the pod. So we are going to be giving you our take the following week. So not quite a reaction episode, but we'll cover them. And the good news about that is it'll give us a chance to like marinate in some of it. Cause Aaron Hawley is going to, like, I'm already imagining the exchange between Aaron Hawley and Amy Coney Barrett. And protecting kids who are just trying to feel comfortable in their bodies and punishing people who want to help them feel comfortable with the touch of the Lord.
Oh, God. What else do we have?
We are also going to get into California's redistricting fight and why it is a crucial issue for reproductive rights and justice. Jody Hicks, who's president of Planned Parenthood California, is going to walk us through the ballot initiative there and explain why Planned Parenthood is involved in this fight at all. Because truly, what is Planned Parenthood doing in a redistricting battle? Inquiring minds want to know, Imani.
And the redistricting battle, for those who have been just too overwhelmed with all of the shit that's coming down, that is Gavin Newsom and the California state legislature's answer to what Trump basically told Texas to do in terms of gerrymandering Democrats out of seats.
We may be off to the races with states gerrymandering because now the Supreme Court has said, hey, man, that's an issue for state courts to resolve, not our problem. And finally, well, not finally, but finally for this episode at least, conservatives are trying to rocket docket a challenge to state shield laws, right? We've got Louisiana. Again, apologies to our friends in Louisiana, but your state's doing the most right now. Louisiana has just indicted another abortion provider across state lines, while Republican attorneys generals are begging the Trump administration to do something, anything, please, about the fact that states like Colorado, New York, and California have laws that protect patients from out of state who access legal abortion care here in places like Colorado and New York and California, and protect the doctors who provide it. So, yeah, they're trying to get that up there quickly. We may see a resurgence of Comstock as a result of it.
Just all of the rocket docket, shadow docket, letting Trump do whatever the fuck he wants. Apparently the power of the purse is no longer Congress's to hold. It's the Trump court. And the fact that someone like Joan Biskupic is saying it is a big deal because it's freaking Joan Biskupic. It's not like one of us, ragtag legal journalists who are just out here fighting the good fight. So that's going to be it for this episode of Boom Lawyered. If you would like to talk to Jess or me about any of this stuff, about conversion therapy bans, about why Alito thinks it's racist to try and figure out whether or not shit is racist, you can find both Jess and I on Blue Sky. We're both kind of dipping our toes into Threads. Jess's Instagram is mostly like Christian influencers and stone fruit. So you might not catch a whole lot of abortion stuff there. But please make sure to talk to us. We love talking to you. And you should follow rewirenewsgroup.com on all of the things: Instagram, Blue Sky, TikTok, Threads. And, what are we going to do, Jess?
We're going to subscribe to Imani's new newsletter, and we're going to see you on the tubes, folks. This
is Boom Lawyered, a Rewire News Group podcast produced and engineered by Chapter 4 and available on YouTube, Apple, Spotify, and wherever else you get your podcasts.